Very warm good evening to all. Today's topic is about Domestic Violence Act. The act itself, like the from the words itself or definition or the name itself, it says that it is for the woman. So it is one law which is actually very small, but if you read it, hardly there are 35, 36 sections in this. But if you read it, it is completely helping the woman. In fact, I would say complete family court matters can be summarized except divorce in the Domestic Violence Act. There are so many sections which are so useful. In fact, it takes into account some of the civil nature type of reliefs as well, such as rent can be given to the parties, that is the woman. Also, the sisters, mother can also be covered. It is not only for women, it does not mean only in wife. It is also for the sister, for the brother, for the sister, and the dispute between brother and sister or the daughter. So it is actually very useful act. And as we go on reading, I will be reading some of the important sections and will be discussing two important decisions of the Supreme Court. Now, the first very important section you should go through is about the definition. Now, definition are mentioned in section 2. Now, there are many definitions. I will take a few of them. That is, one is aggrieved person. Who can be aggrieved person? As I said in the beginning, a woman can be aggrieved person. This woman can be sister, can be wife, can be a person who will be in a domestic relationship in the nature of marriage. And now, what is domestic relationship? We will be discussing with the help of two judgments. Yeah, it may be a now dowry definition is also given. There is a medical facility matter is also discussed. There is monetary relief also. Now, section 2 is very exhaustive. So, whenever you are drafting, you should look into section 2. Now, next section is section 3. Now it speaks about the domestic violence. And now domestic violence can be of any nature. Violence does not mean that a person coming and beating up the another person. No, it's not like that. It can be physical, it can be sexual, it can be verbal and emotional, it can be economic abuse. See, you can cover so many things. It can be physical, sexual, verbal and emotional and economic abuse. Some brother may have cheated the sister. See, everybody thinks the domestic violence relationship does mean only between the husband and wife. No. If the sister has been cheated by the brother or the father or any person with whom she is having in domestic relationship, then she can go and file a case under this act. So it is very useful act. Now next we jump to the section 12. Now, section 12 again says the aggrieved person or another person on behalf of the aggrieved person. Who can complain? It says that aggrieved person herself can go. Otherwise, if she is unable to go for some reason, then also the person who is the caretaker or who on behalf of it may be an NGO also. It may be a mother. It may be somebody else. Of course, there are very few matters which have come to the this way to the court, but then there is a provision that the agreed woman, if she is unable to go, her parents can go, other family members can go. In fact, her next neighbor can also go. But then only condition it will be that he or she should have a consent of the same person, or she or he should be a caretaker of the same person. So this is what is required. And the another important thing that these applications made in this act, interim applications should be decided within 60 days. That is what the law says. But due to the heavy workload in the courts and heavy pendency, these matters cannot be decided in 60 days. But you can always make a request to the court that kindly, as per the law, in 60 days the application should be decided. But now only 3 months, 4 months have gone. You can always say what is the urgency. Now next we go to the section 17. Now section 17 is right to stay in a shared household. Right to stay in shared household. See, we have all heard about the matrimonial home. See, matrimonial home belongs to the husband and wife where they have resided lastly, or they have resided during their whenever their if there is 15 years marriage, they must have resided in so many places. But then that is the matrimonial home. But here the word used is shared household. see why this word, the legislature has used this word shared household, because they know it is not only about the wife, it may be about the sister, it may be about the mother, it may be about the daughter. So the domestic violence act covers lot of areas, and all, in fact it provides lot of relief to the women in all kinds of the relationship. It may be, as said by sister, because everybody says only the even the, in fact I have seen case where mother-in-law has filed a case against the daughter-in-law. How it will stand, we will see in the near future. But what is important that a woman can also use this act. And when a wife is also, mother-in-law has also used this act. How she is proving it is a different matter altogether. But if she is also having domestic relationship with the daughter-in-law and she is troubling, even she can file. Now, when we speak about the shared household, always remember shared household is like a where she has been residing, or where she has a, whether she has a right or title or interest on, even if she does not have, but she has been residing. The only criteria that she has been residing there. Next is very important section, that is section 18. Now here section 18 is about the protection orders. Whenever you apply under Domestic Violence Act, you will be requiring to mention this section that you are seeking the protection order under section 18. Now there are many orders which we have seen, but see section 12 and 18 are also very important. It will be like common sections, whatever relief you are asking from the court. Now, if you read section 18, it is very exhaustive. Let's read it to understand it better. I hope the screen is, you can sharing the screen. It's a very small act. If you read it, you will be get a lot of insight onto this. Now, protection orders. See, the protection orders, the magistrate may, after giving the aggrieved person and the respondent an opportunity of being heard, and on being prima facie satisfied that domestic violence has taken place or is likely to take place. See, the word used, has taken place or likely to take place. Pass a protection order in favor of the aggrieved person and prohibit the respondent from committing any act of domestic violence, aiding or abetting in the commission of act of domestic violence. There may be somebody who is just instigating, entering the place of the employment of aggrieved person, or if the person aggrieved is a child, it's school or any other place frequented by the aggrieved person. The aggrieved person here is also protected at the place of his her employment, or the school or a college. See how it is. Attempting to communicate in any form whatsoever with the aggrieved person, including personal, oral or written or electronic or telephonic contact. Even by telephonic, somebody is every day threatening you, you can file. If your brother is, but you should have a domestic relationship. That is very important. Next is alienating any assets. See, this is as in the said in beginning, it is little bit of exhaustive and carries some civil types of relief as well. Now, alienating any asset, that is transferring any asset, operating bank lockers or bank account used or held or enjoyed by both the parties, jointly by the aggrieved person and the respondent, or singly by the respondent, including her stridhan. See, the stridhan is mentioned in section 18, or any other property held either jointly by the parties or separately by them without the leave of the magistrate. Now here stridhan is also mentioned, bank lockers are also mentioned, operating bank accounts are mentioned, any alienating any asset, that also includes the property, causing violence to the dependents, other relatives, or any other person, any person to give the aggrieved person assistance from domestic violence, committing any other act as specified in the protection order. See, protection order is so exhaustive. If you read, you can bring all the things. Because many times when we say he is operating my bank lockers, I find many women who say my bank locker is in my name, but the key is with the husband, or it is jointly. So he is also operating and he is not allowing me to operate. In those conditions, this section will come into your help. Now next is residence order. Now this is another again civil type of nature, but this is also included, though it's a, see, whenever you are saying reading this act, you will find That the word uses magistrate court, you are seeking the relief. Now here see, residence order is also very exhaustive. While disposing of an application under subsection 1, L of section 12, the magistrate may, on being satisfied that domestic violence has taken place, pass a residence order restraining the respondent from dispossessing or in any other manner disturbing the possession of the agreed person from the shared household, whether or not the respondent has a legal or equitable interest in the shared household. See, you need not have the title. Only criteria is it is shared household, you have been residing there. Directing the respondent to remove himself from the shared household. The court has a power to direct the respondent that he or she should go outside. But there is one hitch to this, which I will discuss at the end. Restraining the respondent or any of his relatives from entering any portion of the shared household in which the agreed person resides. If there are two rooms and one room is given as a protection or as a residence order, if that person enters that room and disturbs the agreed person, the court can always take the action. Restrain respondent from alienating or disposing of, they sell off the shared household or encumbering the same. Now here see, when you go to the court, civil court, it may take some time, but here it is so easy that with one small application, you can get the stay here in a form of the restraining order, restraining the respondent from renouncing his rights in the shared household, except with the leave of the magistrate. There are some cases where the husband has the house in his name, and he, what does he do? He just transfer in his mother or some other relative's name or just sell of it off. Now here he cannot renounce his rights. So this is also a relief you can get from the court. So you have to read the act and you will find the answer. The next is very important, directing the respondent to secure same level of alternate accommodation for the agreed person as enjoyed by her in the shared household or to pay rent for the same if the circumstances so require. Here I would like to give one example. In one of my case, the husband before filing a divorce case sold off the house. Now this lady has no place to stay. Somehow she secured something on the rent, but she was unable to pay the rent. Under Domestic Violence Act, she was awarded the rent. But only, see, if I had gone to civil court, it may have taken some time. But it is so easy because before she was actually living in a house. Now here when we talk about that if the husband has sold off the house, where does the wife go? This is an act which will come to her aid. Now the last line is very important here. Provided that no order under clause B shall be passed against any person who is a woman. A residence order cannot be passed against a woman. So always remember this. So there are some cases where the whole property in the mother-in-law's name. It will be a shared household, but then it will be very difficult to get an order. So it will actually depend on the peculiar circumstances of the case. Now next we go to the section 19, and the one point is very important, that is point number 8. The magistrate may direct the respondent to return the possession of the agreed person, her stridhan, or any other property or valuable security to which she is entitled. There may be a valuable property, valuable security, or anything, and it may be as small as a stridhan. Stridhan is not a small thing, but even if property or valuable other things are maybe shares, see, which were gifted to her, or maybe it was it belonged to her husband and husband is no more. She may be a widow also. The magistrate may direct to see here again a stridhan. For stridhan, Indian Penal Code 406 also you can apply. Along with the 490, you can go to the police station and lodge an FIR. Also, you can under Hindu Marriage Act go to family court. Under section 27, you can ask for the return of the proper stridhan. Section 27 neutral, gender neutral, but there also you can request for the stridhan. But this is one case where you can request for the stridhan. Now next is section 20. This is again all the crux of the matter comes here. It is about the monetary relief. Now when we speak about the monetary relief, it can be anything that is maintenance. It may be medical expenses, it may be school expenses, it may be something contingency expenses which you are asking from the husband, or maybe some other person against who has filed. It may be brother also, it may be a father also. Now here what you have to say, that the monetary relief can be not only for the purpose of maintenance. It includes everything which is also rent, which is also medical bills, which may be some, if you are maybe a property which he has sold off, it belongs to you and he has sold off. You can always ask for the same money, because in one of my case, the husband has sold off the property after taking the power of attorney, and then he was not remitting the money, self proceed. But this act came to be useful to us in that matter. So you can show to the court that the money, the property is sold, and this money can also, money which he has not remitted to me of my share. You may be in a jointly holding the any property or house which your husband or brother has sold. In those cases also you can apply this act. Next is section 21. This is about the custody order. Now custody orders here, it will be given to the, of course, the agreed person, woman. If the children are in the husband's custody or somebody else, maybe father-in-law or mother-in-law's custody, she can ask the custody. She can also ask the right to visit if the children, because of some reason, children are not coming to the mother. She can always ask for the to meet the child. So this is again a shortcut for the custody order, because if we go to family court, it may take some little few much time here, but it will be really easy here. Now next is order 20, section 24. All the orders passed under this act, the copies of the same will be provided to free of cost to the petitioner and the respondent or all the parties here. So anybody who is have applied for domestic violence case or for some relief, and if any order is passed, the order copy will be given you free of cost, whether you're applicant, petitioner, or respondent, that is opponent. So you need not apply. The lawyers here will all be very happy that you need not apply, because sometimes we do not read the act, we apply for certified copy. But here we know that certified copy, there will not, certified copy will be given free of cost, but it will be only one time, surely, not all the time. Next is section 27. This is again a very exhaustive. Jurisdiction wise, see, whenever you file a case, it is very important that the first thing you have to look before drafting whether you have a jurisdiction to file this case and in which court. Now here, where the one jurisdiction where the aggrieved person is residing, another where the aggrieved person is employed, or she has recently shifted because of the husband's or any other respondents or in-laws trouble, she has shifted to some other temporary place. Also where the respondent is carrying on business or residing. See, there is a possibility that a respondent is residing at Thane but is employed at Mumbai. So you have a jurisdiction to file at both the places, Mumbai and Thane. Though he may be, because you may be residing at Mumbai and the respondent is your husband or brother is employed in Mumbai, and he is residing at Thane. The offense or domestic violence may have taken place at Thane, but you have a choice to file at any of the places. Another point here is that also there is a possibility Mumbai and Thane are two places, and the Domestic Violence Act may have taken place at somewhere another place, that is in Palghar district or Raigad district. That place also you can file. So domestic, there are three jurisdictions basically. So this section 27 is also very important and very useful, because sometimes you have to file the case where which is near to you or to your client, or which you feel that you are familiar with this court and the premises and also the procedures in that court. Next is very important, that is section 29, that is appeal. Now here the appeal from any order. Appeal does not mean that finally it has to be decided, then only will appeal. If you read section 29, appeal from any order, not only final order. पूरा डोमेस्टिक वायलेंस का केस खत्म हुआ, उसका अपील की बात नहीं कर रहा है, वो भी कर सकते हो, but appeal from any order, even if summons are received by your client and you feel there is no domestic violence, you have a good prima facie case, then also you can challenge that summoning order of in the domestic violence case before the session court. So you need not go to High Court. Normally we go to High Court for quashing the proceedings, but there is a Gujarat High Court judgment which says that you can, this domestic violence proceeding cannot be quashed because they are not registered as under Indian Penal Code. So 482 CRPC will not be applicable. It will be applicable along with the writ petition. That is article under Article 226, 227. So this is also very important that you should know. This section is also very important. Now, next section, again very important, section 31. Whenever your client receives domestic violence papers, he or she feels we will be punished. Now, let me say very clearly that Domestic Violence Act is a quasi-civil in nature, and there is no punishment prescribed under the act. If you read the complete act, there is no punishment prescribed except section 31. Now here, when section 31 you look into this, you will find that punishment is up to 1 year or fine or both. Fine may be up to 20,000. It is only when the orders of the Domestic Violence Act, whatever are, if there is a relief given to the petitioner, and if they are aggrieved person, and if they are not obeyed by, orders are flouted, they are violated, then only you can apply under section 31, that is penalty for breach of the protection order by the respondent. Now here, always remember that when this act, if you read section 31 right now also, if it is in front of you, you'll find that in the later part, it always say that whenever you complain that the respondent are not obeying the orders, the court will frame the charges, and the court is satisfied. If it's a married woman, it can also frame the charges under section 498A. So it is very important section, which is normally we ignore because we do not know, because nobody reaches up to the section 31. Also, one more important point I would like to tell all of you here, that you can also apply for attachment of salary in Domestic Violence Act. There is a Bombay High Court judgment and Delhi High Court judgment. We'll be taking up another lecture also where I will be discussing the judgments. Today I will be discussing two important judgments because there is a lot of confusion whether the extramarital affairs are covered under the Domestic Violence Act or not. The answer is no, and who says it? Supreme Court says so. Let me share these two judgments with you. One is, this is Indra Sharma, was a VK Sharma. Now, if we read the para 65 here, we are therefore of the view, what was held and observed in this matter, let me read out to you. We are therefore of the view that the appellant, having been fully aware of the fact that the respondent was a married person, could not have entered into a live-in relationship in the nature of marriage. All live-in relationships are not relationships in the nature of marriage. Appellants and the respondent relationship is therefore not a relationship in the nature of marriage, because it has no inherent or essential characteristic of a marriage, but a relationship other than in the nature of marriage, and the appellant's status is lower than the status of a wife. See, this is an answer. Those who are thinking live-in relationships are allowed, and that relationship would not fall within the definition of domestic violence relationship under section 2F of DV Act. If we hold that the relationship between the appellant and respondent is a relationship in the nature of marriage, will be doing an injustice to the legally wedded wife and children who oppose that relationship. Consequently, any act, omission or commission or conduct of the respondent in connection with that of any type of relationship would not amount to domestic violence under section 3 of DV Act. See, this is very important judgment which says that the live-in relationship, all the live-in relationship will not be covered under Domestic Violence Act. Now, what is the criteria? Even if there is a two people who are in a relationship, they may not have married. Now, what are the criteria? There is another judgment which is very relevant, and it is 10 years old judgment, more than 10 years old judgment. It is D. Velusamy. See, what are the conditions? This is para 33. In our opinion, a relationship in the nature of marriage is akin to a common law marriage. Common law marriage is required that although not being formally married, अगर formally married नहीं है, What are the requirements? The couple must hold themselves out to society as being akin to spouses. They should hold themselves as spouses. ऐसे नहीं कि छुप छुप के रह रहे हैं. They must be of a legal age to marry. She cannot be minor. He cannot be minor. The boy should be 21. The girl should be 18. They must be otherwise qualified to enter into a legal marriage, including being unmarried. See, the C is very important here. When they are talking about live-in relationship, they should be unmarried. That is the one quality or one characteristic is required, more than quality, sorry. It is they should be unmarried. If it is one of them is married, whether the lady or the male member, then it will be an extramarital affair. It will not be covered under the under the Domestic Violence Act. Next is D. They must have voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. It's not that just for 2 days they have stayed together, 3 months there. For a significant period of time, they should have. Significant means बहुत ही ऐसे बोला जा सकता है कि महत्वपूर्ण समय, ऐसे नहीं कि 2 दिन रहे, फिर 3 दिन रहे, फिर 4 साल नहीं रहे, फिर 2 दिन रहे. Significant period of time there. So this is para 33 is very important from this judgment. So if you are filing a case where you are seeking that domestic relationship, where you are finding a client where she or he says that we are in domestic relationship, these conditions are to be fulfilled. And without these two judgments, it will not be helpful to you. So this is all about today Domestic Violence Act. It is a very small act, but if you go to read this, you'll find that you will get all your answers. And in fact, it is a summary of all the matrimonial disputes, except one thing, that divorce cannot be granted under Domestic Violence Act. Otherwise, all the relief are available. And I feel sometimes there is no need to go to family court unless and until my client wants divorce. Anybody wants to ask questions? You can unmute yourself.
Yes, ma'am. Good evening. Sanjay Ranpes here.
हाँ बोला sir, बोला.
Ma'am, thank you for the speech. And
हाँ.
just we would like to know about protection officers and the procedure, how to, what are the functioning, how it protection officer functions. Means lady first go to protection officer, or through advocate she can directly file in the court regarding this domestic violence.
There was one judgment previously. We said domestic incident report from the protection officer is very important. Nowadays nobody files that. Sometimes court directs it, but nowadays even lawyer can file directly. There is no need, because law itself says the agreed person can go directly, or protection officer.
Okay, ma'am. Thank you, ma'am.
आणि आता पोलिसांकडे किंवा इतका वेळ नाहीये की प्रत्येकाचं कंप्लेंट एंटरटेन कर. ते लोकच पाठवून द्या, तुम्ही जा वकिलाकडे आणि फाईल करा.
ओके, थँक्यू मॅम.
मॅम एक क्वेश्चन होता की जे डोमेस्टिक फायनान्सचं सेक्शन 18 आहे, 18 मध्ये आपण जे म्हणतो लिगल असेट जे आहे त्यानं त्याच्यात स्टे आपण घेऊ शकतो का एखाद्या प्रॉपर्टी?
ऍक्च्युली द वर्ड यूज इज नॉट परफेक्टली स्टे, बट रेस्ट्रिक्शन म्हटलं तरी ते स्टे मिळतोच ना असा, म्हणजे जैसे ते स्टेटस को मेंटेन करा. स्टेटस को इज लाईक
स्टेटस को मेंटेन.
तेच सांगतात.
पण आता ती फक्त दोघांची जॉईंटली प्रॉपर्टी असू शकते की
इट मे बी जॉईंटली, और इट मे बी हर ओन प्रॉपर्टी, और इट मे बी husband property shared household where she was residing. Matrimonial house को आ सकतो. In matrimonial house the definition is very small, but this definition of the shared house is little bigger, very exhaustive one, which covers lot of things.
आणि ancestral property असू शकते का?
See, ancestral property
वडिलोपार्जित.
see, shared household itself means that all the properties, right?
नाही, 18 सेक्शन 18 मध्ये जे आपण म्हणतोय, जर समजा त्याच्यापासून ते इन्कम मिळवत आहे, आता समजा
एलिनेशन मध्ये आपण सांगू शकतो दे शुड नॉट एलिनेट इट, राईट?
अलाइनेटिंगच्या संदर्भात अलाइनेटिंगचा जो इश्यू होतो त्याच्या संदर्भात आपण अनसिस्टर प्रॉपर्टी जी आहे ती विकू नये म्हणून आपण
यू
असं
कॅन
काही
यू कॅन गेट दे की माझं त्याच्यामध्ये माझं बेनिफिट आहे और आय विल बी डिप्राइड ऑफ माय राईट. यू कॅन ऑलवेज से दॅट.
हा ओके थँक्यू.
थँक्यू.
मॅडम माझा एक क्वेश्चन आहे मॅडम.
हा बोला ना, कोण बोलतंय?
हॅलो, हा योगेश यादव बोलतोय,
हा बोला.
LLB स्टुडंट सेकंड इयर. समजा 21 अंडर मला विजिटेशन राईट दिलेत मुलाला भेटायला, पण ते अपोजिट पार्टी फॉलो करत नाही DV मध्ये.
राईट टू
तर
वुमेन ऐका ना, विजिटेशन राईट टू वुमेन
हा
रिस्पॉन्डेंटला नाही. वाचलं तर बघा, सेक्शन 21 वाचलं ना, इट इज ओनली टू वुमेन. काही कोर्टामध्ये दिले आहेत असे, पण इफ यू रीड दिस सेक्शन इट इज ओनली टू वुमेन. हॅलो, हा बोला सर.
हॅलो मॅम.
हा बोला.
एक क्वेश्चन असा होता की मला कस्टडी मुलाची द्यायचीच नाहीये वडिलांना बिकॉज ऑफ सम इन्सिडेंट्स की आय नो की ऍक्सेस किंवा व्हिजिटिंग राईट्स किंवा कस्टडी मी दिली तर त्या मुलाला हार्म होण्याची शक्यता आहे.
हा,
So,
मग
अशी
त्याच्यामध्ये
काही
जसं
provision-
प्रोव्हिजन आहे, ऐका, बट देन यू शुड बी एबल टू नो पॉइंट इट आउट. तुम्हाला कोर्टाला पॉइंट आउट करायला आहे. डोमेस्टिक व्हायलन्स ऍक्ट मध्ये असं प्रोव्हिजन आहे की ते हार्मफुल आहे. विजिटेशन बाय द रिस्पॉन्डेंट इज हार्मफुल, तसं आहे. पण दॅट यू शुड बी एबल टू कन्व्हिन्स दी जज. तुम्हाला कन्व्हिन्स करावं लागेल की त्याला भेटल्यामुळे हार्मफुल आहे, मागचा इन्सिडेंट आहे तो तुम्ही सांगा तिकडे कोर्टात.
करेक्ट आहे, पण आता जर का रिस्पॉन्डंट ड्रिंक्स घेऊन आणि असे काही ऍक्ट करत की त्यावेळेला त्याचं काही प्रूफ वगैरे नसणार, ऍज अ एव्हिडन्स आय कॅन प्रूव्ह की, पण मी
कोर्ट
सांगू शकते
एव्हिडन्सवर चालतं. नाही, कोर्ट एव्हिडन्सवर चालतं, काय करणार.
मग अशा केसेसमध्ये मला जर का माझ्या मुलीला प्रोटेक्ट करायचं असेल आणि अशा त्या मोमेंटला काही असे काही incident
काहीतरी तुम्हाला
झालेले असतील,
दाखवावं लागेल ना, काहीतरी. तुमची मुलगी किती वर्षाची आहे?
2 वर्षाची.
हा, मग ती बोलूच नाही शकत. आणि मागचे
Correct,
इन्सिडेंट
correct.
काय आहे ते तुम्हाला सांगता आले पाहिजे, काहीतरी सांगता आलं पाहिजे. कोणतरी एव्हिडन्स दाखवा, तुम्ही कुठला तरी विटनेस आणा की त्यांनी मुलीला असं वागवलं किंवा काहीतरी असं कृत्य केलं विच वॉज नॉट गुड, की म्हणजे त्याने, किंवा मुलगी अजून 2 वर्षाची खूप छोटी आहे, इन माय प्रेझेन्स रिस्पॉन्डेंट शुड मीट, असं तुम्ही मागू शकता ना.
हा, कारण आता बरेच वेळेला काय होतं, न्यूक्लिअर फॅमिलीमध्ये हजबंड वाईफ आणि असंच असतं. अशा
हा.
केसमध्ये एव्हिडन्स किंवा विटनेसेस असणं त्या मोमेंटला एखादं काही दोघांचं
कठीण
आर्ग्युमेंट झालं आणि हे
आहे. पण
झालं.
तुम्ही आता, तुमची बेबी खूप छोटी आहे, 2च वर्षाची आहे, पण तुम्ही कोर्टाला असं सांगू शकता की माझ्या प्रेझेन्स मध्ये भेटावं आणि ह्याचा खूप गॅप झालेला आहे.
पण मला व्हिजिटिंग राईट्स द्यायचेच नसेल तर काही प्रोव्हिजन आहे का? म्हणजे लाईफ टाइम करता ते रिस्ट्रिक्शन्स
नाही,
मला म्हणजे
बघा, एक बघा, चाइल्ड इज नॉट अ प्रॉपर्टी ओन्ड बाय यू अनलेस अंटिल देर इज अ गुड रिझन. तुम्ही तिला फादरच्या ह्याच्यापासून डिप्राईव्ह नाही करू शकत. यू हॅव टू प्रूव्ह दॅट फादरने का भेटलं नाही पाहिजे.
ओके.
हा.
ओके.
हा.
ओके. आणि अजून एक
मॅम,
माझा क्वेश्चन होता एक डीव्हीच्या केसच्या संदर्भात 60-65 एज अबावची केस आहे ज्याच्यामध्ये घर जी आहे ते हजबंडच्या नावावर आहे, पण ते घेताना प्रॉपर्टीमध्ये ती प्रॉपर्टी घेताना फिमेल जी वाईफ आहे तिचे मॉनिटरी कॉन्ट्रीब्युशन लागलेले आहे, पण त्या प्रॉपर्टीवर नाव नाही लागलेले, त्या प्रॉपर्टीवर नाव लागले हजबंडचं.
ऐका ना,
सो
जे प्रॉपर्टीचं आहे ना, असं आहे ना, वेदर तुमचं नाव असो किंवा नसो, आणि इकॉनॉमिक अब्युज म्हणून तुम्ही त्याच्यामध्ये आहे एक सेक्शन, ते तुम्ही वापरू शकता की माझं मॉनिटरी कॉन्ट्रीब्युशन ते मला परत द्यावं, किंवा त्या प्रॉपर्टीवर विकू नये, एलिनेट करू नये, त्याने ट्रान्सफर करू नये, सेल ऑफ डिस्पोज ऑफ करू नये, म्हणून पण तुम्ही त्याच्यावरून कोर्टाकडे ऑर्डर, इंट्रीम ऑर्डर मागू शकता.
ओके. ती स्टे नसणार पण इंटरिम ऑर्डर असेल, करेक्ट?
हा, इंट्रीम ऑर्डर, सी इट्स नॉट अ कम्प्लिटली सिव्हिल इन दी नेचर, पण तसं स्टे नाही बोलत, पण असं बोलतात, तसंच बोलतात तिकडे.
ओके. ओके.
स्टेटस को मे बी मेंटेन और
Maintain.
ऑर्डर.
ma'am,
Okay. Thank you, ma'am.
Ma-
Thank you.
ma'am, I have a question. Ma'am, I'm a second year student of BA LLB. Ma'am, what if a man wants a relief from a marriage? I mean, is there any provision under the Domestic Violence Act for that?
It's for women. It's for
Okay,
women.
ma'am.
Ma'am,
He can go to family court. He can go to family court, file a divorce or some whatever relief he wants.
And ma'am, even in general case, if man does not want to continue a marriage, he has to file for a divorce. I mean, there is no other way he can get out of a marriage except a divorce, right?
He can go for judicial separation as well. But the judicial separation is like a unuseful decree to both of them, right?
Yes, ma'am. So, ma'am, he can ask for relief by filing a petition or something in the court, right? I mean,
Right.
like a woman can do, even he can do.
Yes. You read the Hindu
Okay.
Marriage Act, you'll find your
Okay,
answer
ma'am.
in section 13.
Okay, ma'am. Thank you, ma'am.
Okay.
Ma'am, but judicial separation is, I think it comes under the divorce only. That's section 13A of Hindu Marriage Act.
Judicial separation under section 10 of Hindu Marriage Act.
Okay, so ma'am, these are the grounds, I guess, ma'am. These are the grounds for the divorce, which are mentioned in.
She was asking, this girl was asking me, if a man wants
yes.
to file a divorce, I said, read section 13, you will find the answer. For judicial separation is section 10 of Hindu Marriage Act.
Oh, okay, got it.
Ma'am, I wanted to ask one thing.
Yes, ask. We have
Ma'am,
one
you
minute.
said that, ma'am, yes, ma'am. Ma'am, you said that the violence could be anything, like mental violence bhi ho sakta hai, right? So I wanted to ask, if a man is in extramarital affairs and the wife is
That is
getting
also
mentally
emotional.
affected, so
That is also
she
one
can
kind of
file
domestic
a
violence.
case
Yes.
under DV, right?
Under DV. That she is getting emotionally disturbed, no? It's a mental torture to her.
Okay. Yeah, mental torture.
To her.
Okay, ma'am. Thank you.
Nidhi Kulkarni has asked the same question. Ma'am, can extramarital affair of the husband be an act of DV against the wife? Yes. It is a domestic violence. Read the act if you have time. Tomorrow is Sunday. There are 92 people. Even if 10 people read the act, they will know what are the relief they can ask. It's a very small. I will be sharing this. वंदना, if possible, act share कर दीजिए ग्रुप में. तो एटलीस्ट सबका एक एक्ट पक्का हो जाएगा. डोमेस्टिक वायलेंस एक्ट बहुत छोटा एक्ट है, ज्यादा सेक्शंस भी नहीं इसमें, हार्डली 12 पेजेस. और आप गूगल भी करोगे आपको मिल जाएगा सबको.